Sakshi Manasakshi. I am Priya Goteti. Welcome to Sakshi TV special immigration show with attorney Ms. Prashanthi Reddy from Law Offices of Prashanthi Reddy, PLLC. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and for general information purposes only. Sakshi TV or its agents will not be responsible for use of this information. If you need any specific legal advice, please contact the attorney directly. So without any further delay, let's start our show. Hello Prashanthi, how are you and welcome to our show.
I am good, thank you.
So Prashanthi, can you provide information about your law offices, practice areas and your experience?
Yeah, my law offices are in Midtown Manhattan. I have, over 20 years of experience in business and family-based immigration. And, you can reach me on my website, www.reddyesq.com.
Mm-hmm. Okay, so today we'll be discussing on the breaking news on today's visa bulletin and H1B FAQs. So do you have any updates on breaking news, Prashanthi?
Yeah, so basically the visa bulletin has moved to the bulletin came out today, and there's been significant movement in the visa bulletin. It's like 7 or 8 months of movement in EB3 and about 4 months of movement in EB2. So what that means is basically that EB3 final action dates were previously February 2011, and now the final action date has come to November 2011. So, so that's a significant move. And then the EB2 has moved also. So EB2 final action date was August 2010, and now it's December 2010. Okay. So that's 4 months movement, and then 8 months movement in the EB3. So what this means is if anyone has a priority date, which is that date or before that date, then they can immediately file for the 485. Or if anyone has, say, an EB2 with the priority date of November 2011, but since EB2 is not current, they could do then, they can downgrade to EB3 and then file for adjustment of status, so 485, I-140 downgrade together next month. So this is important that they do this immediately because these are the dates for June and July. They might go back, we don't know, or move forward. We don't know really what will happen. So it's always better to be, ready to file in June, and we have 2 weeks. So, that should be sufficient time to get yourselves ready.
Mm-hmm. So before we get into the topic, you can call us on the numbers on the screen for the questions related to immigration and also ask some tips. So I just wanted to ask this a very frequent question. While somebody is on a vacation and they're outside US, can a person's H1B be cancelled by his or her employer? And if so, how can they return back to US?
Right. Yes. So getting into our topic, which is basically frequently asked questions on H1B, we've just gathered, all the questions that we get in our firm and all the questions that people usually ask us on forums and, webinars, and we've gathered it in one place and decided to do a show on, frequently asked questions. Because, I figured rather than doing a show about what is H1, that is important also, the educational part of it, but it's also important to touch on, these frequently asked questions. So thanks, Priya. And so that first question that you asked was if they're outside the country, mm-hmm. and then the employer cancels the H1, what happens to them? So basically, when you're not in the country, you're not on any status really. You're not on H1. You have to be in the country to be in some US immigration status. If you're outside the country, you're not in any way subject to the US immigration laws. But mm-hmm. Yes, coming back, you have to have some kind of you have to have a visa, or you have to, and an unexpired I-797 or I-797 that has not been withdrawn. So if your employer has withdrawn the H1 approval, that's the I-797, you cannot come back using that. So you'll have to then file for another H1 for consular processing, and then you can come in. You don't necessarily need to get another visa, but you can file for consular processing. If you have a visa that's already valid, you can just use that and come in. You don't have to go to the consulate each time.
Okay. And also, like people will be transferring their H1 visas. So during this H1 transfer, can the new employer start running the payroll before it gets approved?
Yeah, so that's the good thing about portability. That's pretty much called H1 portability. So based on this H1 portability, once you file, once the case is received by USCIS, you can actually start working. So if you have a FedEx, if you're sending it by FedEx, and you have a receipt, you have a confirmation of a receipt, right? You can track on FedEx or UPS or whatever. Then you can start working. The only problem with this is, suppose the case comes back because you didn't include the right fee, something is not signed, then that person's status is in jeopardy because they have started and there is no H1 filed, right? Because the case came back. So there's some risk in doing that. And also, so what if the case gets denied? Then the person falls out of status unless they can go back and join the previous employer. And oftentimes, if you leave, the employer will withdraw the H1. So you might not have that opportunity either. In which case, then you'll have to leave the country, and then they'll have to refile, your employer will have to refile the H1, and then you'll have to come back in. So that's, what it is. That's how things work. So there's some risk involved. Even though you can work, there's, there is some amount of risk. So you have to be aware of that.
So I think it's better to wait until the H1 gets approved, then move to the new employer. So
yeah, so you can wait, you can do premium processing so it gets approved faster. And then once it's approved, then you can move. That might be a more prudent thing to do. Sometimes people don't have that option. They have to move immediately. But, sometimes it's possible to wait. So wherever it's possible, I think it's a good idea to wait.
Okay, so we have a caller, Prashanthi, Kiran from Maryland. Hi, Kiran. Hello. Kiran? Okay, let's move to our next question. We hear that many people saying that they have a pending labor certification. So what exactly it means, like what pending labor certification means?
So pending labor certification is nothing to do with the H1. It's for the green card.
Okay.
Right? People get confused when between labor certification and labor condition approval. So there are two different things. Labor certification is for green card, and LCA or labor condition is for H1. So before you file a H1, you have to file an LCA, which is a labor condition, and get the LC approved. So you need an labor condition approval before you can actually file your H1 with the USCIS. So it's a two-step process. First, LCA approval with the Department of Labor. Basically, the LCA is being approved for the job, the work site, and the salary. And then once you get that, that takes about 5 to 7 business days. Once that is approved, then you have to attach that and then send your H1B related forms, the I-129, I-129H, I-129DC, and all the rest of the package to USCIS. So if you don't have an approved LCA before you file, or if the approved LCA is not signed or is incomplete or not approved, and then you send that, the entire H1 will get denied. And there's nothing you can do to correct it, even if there's an RFE, because you would not have had an LCA before the filing of the case. So you just have to refile.
Okay, we have, I think, Kiran back on the line. So hi, Kiran. Hello.
Yeah, hi. Yes.
Yeah, please go ahead with your question.
Yeah, hi, ma'am. This is Kiran from Maryland. Yeah, my H1B extension is filed on April 30th. So it's almost 20 days back. On premium basis, it was filed. So till now, there is no update from my attorney. So they haven't received anything. So my question is that it's only it should be by 15 days, right? Or if that doesn't happen, the fee will be refunded, right? So that's what my question.
So you have not received any kind of receipt?
No receipt, no update, anything.
So premium processing or not, you should receive at least a receipt showing that your case was fee. So that is unusual for it to take 30 days. It usually doesn't take 30 days. So just make sure that the employer has actually filed it. And if they have filed it, then you need to call. If it's premium processing, it's easy to contact them. You can't, but your employer or attorney has to. Premium processing is they're much more accessible. You can send them an email, easier to contact. So they can find, look for your file. But it's unusual not to get a receipt for a month. Usually takes about 10 days, 15 days.
Yeah, it's already 20 days. So, okay. Yeah.
Right.
So ultimately, I need to contact
and
my
also
attorney.
Also see if you ask your employer, since the employer would have given a check, ask the employer to see if that check has been cashed. If the check has been cashed, a receipt number will be there printed at the back of the check when you get the returned check from the bank. So that's another way of finding out whether it was fee receipted, even if you didn't get the notice for some reason.
Okay. Thank you.
You're welcome.
Yeah. Thanks, Kiran, for calling us. We have another caller, Lohit from Texas. Hi, Lohit.
Hi, my name is Rohit, and I had a couple of questions. So the first question is, I heard the H1B transfer for normal processing has been quick off late, so it's kind of taking 2 to 3 weeks. So any insight on that? And the second question is it okay to start on receipt?
I think you must have heard our discussion just now about the receipt. Yes, it is okay, but there is some element of risk, right, that you're taking in case the case is returned because of some error or if it's rejected. So that's the risk that you're taking. If you're confident that your previous employer will take you back, then there is no risk. But if that option is not there, then there is some amount of risk. So that's something that you need to. A lot of people still do it, so that's something that you need to assess and see. But if you don't want to take the risk, then it's a good idea to do premium processing, and then in 30 days, if you get the approval, then that should be a reasonable amount of time to wait. It really depends on your circumstances. And transfers, yes, they're not taking very long. I don't exactly know if it's 2 or 3 weeks, but it's about a month or so. So we have not had any issues with H1s, especially with transfers. The cap cases, also we've received approval. So usually anyway with transfers and extensions are a little bit more lenient. And with this whole, employer-employee relationship, all this out the window, it's RFEs have really gone down. So it's a much better outlook for H1s this year.
Okay. So is it advisable to just tell my current employer to hold on with my H1B, not to withdraw it unless I kind of get confirmation from my future, the prospect, where I'm trying to move?
Yeah, that's a good idea if your employer is willing to do that. But usually once you leave, the employer is mandated to, it's a law, you have to withdraw the H1. As an employer, they have to do certain things, and that's one of the things. So if they're able to hold off maybe they can for a short period of time without breaking the law, but otherwise they're required to. So most employers will withdraw the H1.
Okay, all right. Yep, that sounds good. Thank you so much. Yeah.
You're welcome, Rahul. Take care.
Thanks for calling us. So, Prashanthi, a brand new company with $0 revenue, can they apply H1B visa? And if at all they applied, will it get approved?
Yeah, so really the size of the company is not important when you file a H1. What is important is that a company exists, that they have a proper office space, not operating out of home or a virtual office, and that they have work, that the work is not speculative. So they actually, it's not some future availability of work, but they have a present need, a present PO or contract, or if it's not, an IT company or it's not based on POs and contracts, then whatever their job is, they have a present need for you, and they have to be able to document that. So as long as they're able to do that, I don't. The size of the company or number of employees is not important really. USCIS has never, they do send RFEs, but they never send RFEs for that reason. They don't say that you're a small company and therefore we're not going to approve your case.
So, what are the possible cases for RFE, like most common cases for RFE?
There can be many reasons, and that itself will be a whole, 1 hour session as to why we get RFEs, and what are the common RFEs that we get. But if we have more time, we can elaborate on that further later on in the session. But now, I'm just going to give a short answer and say that specialty occupation is one reason. That is basically that, the USCIS is saying the job doesn't require a bachelor's degree in a specific field. Or they may be saying that the job requires it, but the beneficiary does not have the related education. So, that could be the reason for an RFE, or it could be there's some issue with the LCA. And, you put one worksite in the LCA, and in the petitioner letter, in the forms, you put another worksite, right? Or it could be that, whatever it is doesn't match between the forms and the LCA. There could be a number of things that don't match. There's a mismatch somewhere. Or it could be that you haven't shown why you need this employer. You cannot, though you don't have to, there's no right to control or employer-employee relationship or a requirement to send a detailed itinerary, you still have to show that your employment is not speculative. You still have to show you have some need, and you have to document that. So if you don't document it, you're most probably going to get an RFE asking for what the job is. There could be an RFE on the wage level. Sometimes when we use wage level 1, they send an RFE saying that it's not a specialty occupation, which is wrong, but they do that sometimes. So something to keep in mind. So that's another red flag. Sometimes they send RFEs for, if they don't find your company in the Dun & Bradstreet website, if you don't register in Dun & Bradstreet, USCIS follows a system called VIBE, VIBE, and information for that system is fed in by Dun & Bradstreet. So they're looking for registration. So they just want to make sure that your company actually exists. So in order for them to find out whether it's existing or not, they will send sometimes, they'll say, we can't find you in VIBE, so please send us these 10 documents: incorporation, bank statement, copy of your lease, tax returns, quarterly tax returns, payroll statements. They ask for a lot of information with reference to, your company. So that could be another reason for, sending out an RFE. And there could be many other reasons also. It could be your status, whether you're in status or not. And if you don't submit your latest pay stubs, if it's a transfer or an extension, they'll send an RFE asking for your, proof of status. Or if it's a change of status and you have not submitted your latest I-94, they can send an RFE asking for that. So there are many reasons.
Okay. And Prashanthi, if an employer wanted to change a full-time H1B employee into a part-time, so can he do that? And if so, if that happens, will it impact the status of an employee?
No, you can work part-time as well. You can work part-time, 20 hours or whatever it is, and still be in H1 status. And in the way to do that is to file, and a lot of people have done that, during COVID, because, their jobs were cut back, and they became part-time from full-time, and employers had to cut back on their hours. So in that situation, you need to file an amendment from a full-time H1 to a part-time H1. And it's not very difficult to do. And
Okay.
it's pretty much allowed, you're allowed to be on a part-time H1. So, I mean, if it's like 3 hours in a week, then it might be questionable. They might not approve it because they'll say, how will you survive? Right? So as long as it's reasonable, like 20 hours or, some reasonable number, then I don't see why the amendment will not be approved.
So like we generally have this minimum wage rule for this H1, and also once they move from full-time to part-time, obviously the wage would be decreased. So because of that, it won't have any visa issues for the employee, correct?
Yeah, so the wage is an annual prorated wage, right? So it's not like you have to pay X amount of dollars. For
Okay.
example, if a person worked only 6 months, obviously their wage will be less, but that doesn't mean they're out of status. In the same way, if a person is working part-time, then they will be an hourly wage, right? So as long as they're being paid for the time that they work and they're being paid the prevailing wage for the time that they work, it doesn't matter whether they're making 50,000 or 100,000. They'll most probably be making 50,000 if they're working only half the hours, 20 hours, right? Instead of 100,000. But what is important is that they be paid the hourly wage. So if they're working 20 hours a week, and if the hourly wage is say $100 or per hour, as per the prevailing wage, then they have to be paid that $100 an hour. That's the only requirement.
Okay. So we have a caller, Aditya from Virginia. Hi, Aditya.
Hello. Hello, Prashanthi garu.
Hello.
I have a question. Hi. I have a question for the employer change after getting EAD. So currently my situation is that in the recent filing, I got my EAD, and my date is also current from May 1st. My final action date is also current. So currently what's happening is I have an offer in hand, and the joining date for that company is from June 1st. So when you change an employer, so usually it is recommended to file I-485J after you change the employer. But my question is, say like if I change the employer and before I file my I-485J, if my green card gets approved, so what would be the situation? Because since my date is already current, I don't know when it gets approved. But just in case if that gets approved, what would be what is recommended at that point, or is it advisable not to change employer at this moment?
Yeah, so what comes into play then is, obviously I'm presuming you are AC21 approvable, right? In the sense that I-140 is approved and more than 6 months is over since the date of your filing, correct?
Yes, correct.
You qualify for the AC21.
Yes.
So then, and obviously you cannot file AC21 before June because you're not starting work before June, correct?
Yes.
So then if you file, I would suggest just filing it and letting it be part of the record and having proof that you filed it. And then it gets approved, doesn't get approved, at least you will have a leg to stand on saying that, look, I did the AC21 as soon as I possibly could, as soon as I changed my employment. So it's just a coincidence that the green card got approved before that, but I sent in my AC21. I sent in my 485J. So I think you should do it. Whatever time. Simply because now we are concerned about your citizenship. Right? So in order to be qualified for citizenship, you have to show that you worked. It's not a requirement by law, but in general, they will see if you worked for your employer who filed your green card for at least, or for whoever you did the AC21 for at least 6 months after getting the green card. They generally look at that. And if you didn't work, then they'll question as to why didn't you work? So just to avoid that questioning, so that your new employer is your current employer for green card purposes, I think you should file the 485J, whether your date is current or not. Even if it's current, you might get an RFE, you might get an interview notice. It's not necessary that it'll be approved the same month, right? So it might take a couple of months to get approved. So my suggestion is file the 485J as soon as possible.
Okay, Prashanthi, yeah, that was the thing, because it may or may not get approved, just in case, like, if it doesn't get approved, then it's a straightforward case for me to file 485J, but just in case it gets approved. So either way, it's better to file 485J. That's your recommendation.
Correct. Yeah, I think so. Just file it.
Thank you so much, Prashanthi Garu. This helps. Thank you so much.
You're welcome. Take care.
Yeah, thank you for calling us. We have another caller, Srihari from Chicago. Hi, Srihari.
Hi, Prashanthi ma'am. I have a question.
Sure.
So actually, I'm actually currently was working with a employer A, and he used to like hold my pay, saying that they will pay for my H1B extensions and any premium processing and all. And I tried to like change my company to B, and then I have some money in their holding. So I'm trying. When I'm asking to send that money, they're saying that they will not do that. So my first question is: normally for the H1B fees and everything, is it employer that has to pay every time? Like it is mandatory? And if that is the case, then the hold and all, should I actually go and see, like, work with the attorney and file a case on them?
So there's certain fee that has to be mandatorily paid by the employer, and that is the 1,500, 750 that USCIS, that portion of the fee. And also, but other than that, premium processing does not have to be paid by them. So basically, you can even write a check for premium processing. But again, having said that, USCIS will always, on Department of Labor, always frowns upon employers making employees pay any portion of the H1B fees. It might be okay maybe for them to pay for you to pay the attorney portion, but again, it's a gray area. But some things are not a gray area, like that 750, 1,500 that compulsorily has to be paid by the employer. And if they file a green card for you, then the attorney fee for the perm has to be paid by the employer by law. So I would say that if the only thing you need to do is complain to Labor Department that there is certain fee. And again, the other thing, additional thing to keep in mind is that they have to pay you the prevailing wage, and if they have not and they've kept part of it, they cannot say that part of it is for the H1B fees. They have to actually pay it because you worked, right? So you can definitely complain to the DOL, and you can just file a complaint. You don't even need an attorney, and say that this is the amount that's owed to me. These are my timesheets, and I have not been paid, and I would like to get paid. So my suggestion is negotiate with the employer first. Inform them that you will have no other recourse. If you don't pay, I'm sure I'm hoping employer that they will listen to reason. Most employers do. And then if it still doesn't work, then you'll have to do what you have to do.
Okay, sure. That helps. Thanks a lot.
You're welcome.
Yeah, thank you for calling us. And if you have more questions and would like to reach out to Prashanthi, you can email at prashanthi@readyesq.com or call 212-354-1010 or visit www.readyesq.com. So often, Prashanthi, we see that most of the consultant companies, they hold some of the pay to the employees. So if an employee goes and takes some action and all, will it have any legal complications when they wanted to become a citizen or filing a green card, if they have any legal complaints or anything?
No, I mean they're fighting for their rights. They're asking the court to give them what is rightfully theirs. So it's nothing. They're not doing anything that they're not supposed to. In fact, they should be. I mean, public policy encourages them to. The government or the judiciary would want them to file a lawsuit if they are, being unfairly treated. That's why we have the court system. So no, they will not be targeted for filing a complaint or you can even file a complaint against USCIS itself if they're delaying your case, like is being done for the H4 cases. A lot of individuals file mandamus, mandamus claims, and they've sued USCIS for delay in H4 EADs and H4s, etc., I-765s. So, yeah, absolutely not. They can go ahead and file without any consequence to themselves. Of course, Priya, we cannot file a frivolous claim. It cannot be frivolous. But yes, if you have a claim, you should go ahead and file it.
Okay. And during this pandemic situation, we have a lot of job offering remote work. So if an employee starts to work from home, what does the LCA require in regards to this notice? Like if it's a remote work.
Yeah, so you're right. So it's become almost totally remote from the last 1 year, especially in the IT profession. So it's very commonplace to put, the residence, the employee's residence as the workplace in the LCA. It was not unknown of before also, even before we used to do that. It was not, it was becoming more and more common, but now it's just become every single case that you file is pretty much a remote filing. So we just have to put the name of the client that they're ultimately working for, if there is a client, and then you put the work site as remote and put the address and then say home address in the LCA. So they know that it's not an office address, it's a residential home address. And then if you want, you can put a secondary address if you think that if there's a chance that the employee will be going back to work at the physical location, then go ahead and put the client site or whatever if there is going to be a secondary work location as the next work location. So that way, if the work location changes, say a few months later, because they're saying in summer things might open up, you don't have to again file an LCA, again file an amendment. You can just use the same LCA.
Okay. So like what steps does the employer have to take to terminate his obligation, like to pay the required wage?
The wage.
Yeah, required wage.
Right. So you're required to pay a wage as long as the person is working for you. If the person doesn't work, then you don't have to pay. But it is your obligation, as I was mentioning earlier to the earlier caller, that in such a situation, then the employer has to give notice to the employee saying that, you are no longer working for us and we don't need your services anymore as of so and so date. And also the employer then has to withdraw the H1, inform USCIS that employee is no longer working for them, and withdraw that H1B. And if that person wants to leave and go back to their home country, they also have to pay the return flight expenses. So these are the obligations of a H1B employer when an employee leaves.
Okay. And suppose if the employee is unable to work because of COVID or because of any sickness, like for 1 month or 2 months, so still the employer has to pay the wage, or can he terminate the employee because showing this cause?
So two different questions. First question, does he have to pay the wage? If the vacation sick leave was requested by the employee because they are sick, then the employer doesn't have to pay the wage. Of course, there might be some sick leave days not there. We don't know every company has its own policy and every state has its own rules. But from the immigration point of view, if the employer is not presenting himself or herself for work and requests vacation or sick leave vacation, then the employer doesn't have to pay. But if the employer is saying, don't come to work because, you have to be quarantined. Maybe the employee is healthy enough to come and wants to come. But the employer is saying, no, don't come because I don't want to get COVID. You're going to give me and you're going to make everybody else in the office sick. Please don't come. Then the employer has to pay, even though he's doing the right thing. he or she, right? So that's a little tricky. So it really depends on the situation as to who is asking for the leave.
Mhm. So can the employer terminate showing this as a cause like sickness or
Right.
anything? Terminate it?
Yes, I mean the employer can terminate for any reason. As long as there's no other laws from the immigration point of view, employer, it's a free, employer and employee agreement, right? Any person can terminate at any time. Employee can decide to leave, employer can terminate. So there is no obligation on either part to stay in that relationship. So yes, they can, but in certain circumstances like maternity leave, for example, employer cannot terminate because of him. They may not give them paid vacation, but they have to give unpaid vacation for a certain amount of time. Every state is different because that's the law. So this is not immigration law, though this is labor law, employment law, whatever.
Okay.
So as long as there's no law in your state which says that you need to do it, you don't have to do it. Every state is different. So with the COVID related thing, if they terminate, then as far as I know, I don't think it's an issue in most states. But again, it's not immigration law, so we'll have to, don't take my word for it.
Okay. And like many people who are waiting from India for H1B visa stamping, and also, do we have any changes or any new updates on it?
Yeah, I think we covered that update last time. That was a major topic a couple of weeks ago. COVID-19 related, the travel ban related to COVID-19 India travel. So what has happened is a lot of people at that time, because travel was becoming easier. There's cases were lower here in the US, and cases were lower in India also. A lot of people, they waited for things to get better, and then finally went to India to get their visa stamped, and unfortunately got stuck there. Thousands of people, because they announced the travel ban within a week really. There was some inkling that it would come, and then it finally came. A lot of people, even though there was some warning, there was not enough time, because even flights were booked, and then nobody knew that it would actually happen. People also thought it was a rumor, so people didn't take action and try to come back. So a lot of people did, but still there are significant numbers of people, I think, in India stuck. So now there are two things happening. One is, of course, travel ban, which will be there until the COVID situation in India gets better. But it's also a matter of the consulates not working their full capacity, and they haven't been for the past year. Mumbai, Hyderabad, Calcutta, they're always only doing essential services. Only Delhi was taking all kinds of cases, every case. Otherwise, they were just doing emergency visas and essential services. And just when they were starting to open up, for example, Mumbai started opening up family-based petitions, immigrant petitions. Hyderabad, there was a proposal to open up other services. Just then COVID hit. So that was a big setback again for travel. So right now, next few months, I don't think any travel is going to be possible.
Okay.
Until things get better. I mean, one is related to the other, but it's also I think the consulates not reopening is not related to COVID, because there was very few cases of COVID in India, and still a lot of the consulates didn't reopen. So I think that's more, I don't know for what reason they did that. Just maybe a way of stopping people from coming into the US, which was the previous government's agenda anyway. So just a continuation of that, I think.
Okay. So coming back to the RFE, like most people will be worried about RFEs, or they'll get tensed when they see an RFE. So can a beneficiary respond to an RFE, or is it only the employer has to file the RFE?
So a H1 is a petitioner, that is an employer related case. right? It's a work visa, so an employer files it. So unfortunately, a beneficiary does not have any say in the petition, even though they are equally affected. I think that needs to change as a policy, but that's how it is right now. Same thing with the I-140s, the green cards, labor cert and I-140. It's employer related, so the beneficiary does not, or the employee has no say in those filings. So same with the RFE, the employer can respond. I mean, employee can respond with a note, but that has to come from the employer. That has to be sent by the employer.
Okay.
So if there is an employee portion of it, like job duties or something, then, we often get a letter from the employee asking them to describe what their job is and why, a bachelor's degree is required for their job. That kind of explanation, usually the employees can do a better job. So they can write a response, but it has to be ultimately sent by the employer. And if there's any employer portion of it, like if they're asking for employers' tax returns, etc., that, all that has to be responded by the employer on their letterhead or by the attorney.
Okay. So even this is the case with the green card. Can we personally file, or an employee personally file a green card for themselves, or employer has to file it?
So it depends on which stage again.
Okay.
If you're filing the labor and the I-140, that is, both are employer based, so they have to be filed by the employer. With the I-140, recently they've given the employees some flexibility in the sense that if you do a FOIA request, that is, if you want a copy of the I-140 petition under the Freedom of Information Act, then they've given some concession to the employees and they can actually request a copy of their I-140 and, parts of their, whether the labor approval and, most probably the tax return. The tax returns won't be shared, but all the other information will be shared by USCIS. So that's one concession they got. But to answer your question, no, they cannot file. That has to be filed by the employer.
Okay.
And even if they were to file it without anyone knowing, the employer can just withdraw it.
Okay, got it. So the employer, this withdrawing the green card, is it like after I-140, within 6 months they have a capability of withdrawing it, or even after 6 months can they withdraw?
So as per the AC21 regulations, in order to change employers, you have to wait for 6 months from the date of filing the 485 and the approval of the I-140. So two things have to happen. So after that period, if the employer withdraws the I-140, it's still fine. There's no issue with withdrawal because you're allowed to, because of the AC21 rule. But if, say, the I-140 is approved, but the 180-day period did not get over, then if the employer withdraws, then you cannot continue with your 485 will get denied. That's a big problem. You can still use that I-141 for the purposes of maintaining a priority date, but then you have to file a new labor from the new employer, and for also filing a H1, beyond extensions beyond 6 years. You can still use that I-140 if it's withdrawn, but only for those purposes. But you can use it for your green card if that 180-day period is over. Okay.
Like, what is the current trend in the RFE? Like, are we seeing more RFE cases in recent times, or is it a little bit better, relaxed right now?
Yeah, so the trend is that it is more relaxed compared to the last 2-3 years. I mean, last 4 years since 2017. We've seen like 60% of the cases being RFE'd and another 50% getting denied after that. Last year and this year, we've seen fewer RFEs, mainly because some laws have changed. So they're not able to send, and those laws have changed because of some court cases. IT-Serve versus Cessna, in which basically the judge said that the employer-employee relationship memo, the right to control memo, was unlawful. And most of the RFEs were based on that memo. So they were asking for contracts, work orders, client letters for the entire 3 years period. And most contracts are for 6 months or 1 year. It's very rare that a contract will be for a full 3 years. And they were denying cases based on that. Also, for example, they wanted all the contracts between, all the parties. If there were 3 parties, they wanted the master services agreement, the PO, then a letter from every single party involved. And it was not always possible to get that for the employer, and then they would deny on that basis. So they had many reasons to deny. Now their reasons to deny have reduced. So even if they want to, they cannot ask for, right to control and itinerary and to account for every single day where they're going to work for the next 3 years. They can't ask for that. In general, they can ask for documentation to show that the job is not speculative. So if you submit a PO for 6 months, that should be sufficient. Previously, what was happening also is they were either denying the case or they were approving cases for 1 month, 1 day, 10 days, 6 months. That was happening also. So it was a horrible situation.
Yeah,
And
we
then
see some cases like they got approved and it is like next day itself, like only 1 day they were having the time limit and all. Yeah.
Right. And sometimes by the time they got the approval, that time was over also.
Yes.
Because the approval takes about 10 days or so, after it gets approved to reach you. And also with reference to specialty occupation, they just started a whole new, added new ways of interpreting specialty occupation. So, and that made it more difficult. So I think mainly the present administration is less inclined to restrict H1s, but it's not like they've opened it up, but they just want to maintain status quo is my feeling. So they want to go back to, pre-Trump era and then keep it as it is. And even then it was not great, but at least not as bad as it has been, the last, since 2017, the last 8 years. So yes, to answer your questions, the RFEs have become less because of these reasons. And approval rates have definitely increased. And in fact, in our transfers and extensions, we're not really seeing RFEs on regular cases. It's only if you file a H1 for some job title, which is a little unusual, which, USCIS is not familiar with, then they might send a specialty occupation RFE.
Okay. Apart from this RFE, we also hear this like NOID or NOID. So is it same as RFE or is it different?
Yeah, so an RFE is they have not made their decision. They're just saying that, okay, you have not submitted these documents. We need these documents so that we can make a proper decision. In a notice of intent to deny, they have kind of already made a decision saying that we have made this decision, but they're willing to take a second look at it, if you can provide any documentation to, make us change our minds. We're willing to change our minds. So if you get a notice of intent to deny, you're more likely to see a denial, even after submitting documents, when compared to a request for further evidence. There's nothing to be worried about in a request for further evidence. It's pretty routine because most companies will just send basic documents. They don't want to send all the documents, and so they'll get an RFE. NOID is a different thing. It could be that they have done some investigation against the company. They found out maybe there was a site visit. The site visit didn't go that well. So they've decided to, and that's when they usually send NOIDs. They'll be like, okay, we can't, this site visit was done. This particular beneficiary was not at the client site. Therefore, we are going to withdraw your request to amend or extend this case or whatever it might be, because we feel he has not maintained status, because when we went to the office, no one was there. So please tell us why we shouldn't. You have 30 days to submit documentation, to change this decision. So there's a big difference between the two.
Okay. So, if a person gets this notice of intent to deny and all, so is there something to worry about? Like most probably his case it gets denied, even though after submitting the proofs and all.
Yeah, more likely for to get a denial. And usually that notice of intent to deny, you get only 30 days to respond,
Okay.
as opposed to 80 something days that you get for an RFE. The
Mhm.
time on a NOID is much less.
Okay. Prashanthi, if a person is having this RFE and if the employer is not intended to respond to RFE, so what steps he can take?
Who, the beneficiary or the
Yeah,
employer?
the employer is not ready to explain, provide a more documentation for the RFE. So, what a beneficiary can do in that case?
So in that case, the beneficiary then should immediately look for another employer, because usually it takes time for the RFE to, uh, they give sufficient 80 days or so. So while that RFE is still pending, rather than, because after you get a denial, then again, you can't file for a transfer, right? Um, Unless it's a situation where the 60 days grace period applies. So that is where, in a situation where you're being laid off. But in this case, most probably the employer is filing an extension, or so your I-94 may be expiring, so you want to ensure that he responds to it. And if he doesn't, if he's not going to, then you have to file another petition before that RFE response date. And if it's an RFE that was received by March 31st, then remember, you have a 60 days grace period to respond to the RFE because of COVID. But if
Mhm.
you got the RFE later, then there's no grace period, so you have to apply within the assigned time. And usually they give, 2 or 3 months to respond to the RFE.
Okay. And for suppose if a person is on H1B and he gets some stock, he is provided with some units or some stocks. So will it be like he's like a self-employed or a partner to that company, or he can get those stocks?
Right. I guess your question is, if he gets the stocks, can he be on a H1 with that company?
Yes.
So it depends on the situation. A H1B can invest in stocks. Nothing stopping him from doing that. Only thing is, he cannot work actively for a company. So, for example, all like Microsoft employees, all the big companies, right? They offer stock options to their employees as an incentive. So that does not in any way hinder them from getting a H1.
Okay.
But there are situations in which things are not as clear. It's not like they're getting 0.00001% of the company or even less by getting a few stocks, right? It's a multi-billion-dollar company. So it could be a situation where you have a majority share in the company. You may not be running the company because you're not allowed to, but you may have a majority share in the company, or maybe your wife has a majority share in the company. In that situation, most probably you will not meet the definition of an employer and employee. So USCIS might say that we're not convinced that there is an employer-employee relationship here. Because in that case, then anybody could open a company and hire themselves.
Correct.
And though it's not, nowhere does it say that it's not allowed. USCIS will not say that.
Mm-hmm.
They just say employer-employee relationship has to be established.
Mm-hmm.
But so what will happen is they'll send an RFE, even if you have the same last name. We've received so many RFEs where accidentally, like Reddy is such a common last name, or Patel or Gupta. So when the employer and employee have the same last name, they send huge RFEs asking for what is the relationship. And
Okay.
then we have to prove that there is no relationship.
Mm-hmm.
So yeah, it's difficult to, and they may not even have any shares. They're just going based on the fact that they have the same last name. So you can imagine if they actually held shares and they have a majority shareholder, most probably they will not approve it.
Okay. So we have one caller, Rajiv from Ohio. Hi, Rajiv. Hello.
Hello.
Yes, Rajiv.
Hi, ma'am. Actually, my name is Nagi Reddy, not Raji.
Yes,
I'm
Nagi.
sorry.
Oh, sorry. I'm sorry. Yeah.
Ma'am, my question is very specific, actually. I filed for 485, but not for EAD and AP based on my lawyer's suggestion. Before that, just a month before, my H1 got extended for up to 2024 February, and my wife H4 EAD was being filed, but as of now, there is no response. We're waiting for it. My question is now, and also my priority date is 2012 March. So as the dates have been progressing, recently I was thinking, should I go for EAD based on 485 and apply for AP as well? Now, as of today, as the day has been progressed, I'm wondering whether I should hold on. And so I can get the green card sooner than later, or should I just go ahead and file for EAD, just have it in my pocket? That's one question. And the other question that I have is on the same subject line is, if my final action date become current, what could be my next steps? I just have only 485 and my fingerprints has been done.
So, with reference to the first question, I'm not sure why you didn't file EAD and advance parole. You should, because there's no harm in doing it. It doesn't cost you anything extra. So you should have filed the advance parole and EAD because it's a backup, even if you're not using it. Tomorrow, if something happens with your H1, you will not lose your job. You can just switch to EAD, right? So you should have that EAD and advance parole. There's no reason not to file it. We've filed for every single person. Though it's additional work for us, it doesn't cost anything, right? For the client, and it's a benefit to have. So it's important to have it.
Yeah, that was
it
just,
could be just that
misleading from the lawyer. Basically.
It could be that at that time in October, the attorneys didn't have time to file, so they just said we're not filing. That's possible. A lot of attorneys did that. So so going back to your question, you should file the advance parole and EAD and keep it in case you need it. There's no harm in filing, because no one can predict when the dates will become current, whether they'll move forward, they'll move backward. No one knows that, right? So it's just a question of time and money. So I think you should file the EAD and AP. There's no harm in doing it.
Okay. And the next question is, like, if my date becomes final, what would be my next steps? I didn't do my medical also yet.
That was not a good idea. You should have submitted your medical also, because that will delay the processing of your case, because you will get an RFE, and once they ask for medicals, they'll ask for 5 other things, and it just delays the case. So if for some reason your dates become current 1 month and are not current the next month, then that will put a stop on them issuing you a green card, because they can't issue you a green card with incomplete documentation. So if you have not submitted medicals, then you will get an RFE. There's no way you will get an approval without that. You might get a request for an interview. Not everyone is sent an interview notice, but some people are. So that's another thing that might happen, an RFE interview notice. Since you just gave your biometrics recently in October, you won't get a biometrics notice again. So RFE is for certain, and there might be an interview notice as well.
Okay. Thank you for calling us, and thank you so much, Prashanthi, for answering all our questions. If you have more questions and would like to reach out to Prashanthi, you can email at prashanthi@readyesq.com or call 212-354-1010 or visit www.readyesq.com. So we'll be back next week with more interesting topics on immigration. This is Priya Gotiti signing off. You are watching Sakshi Manasakshi.